Okay, welcome back from the break, everyone. Thanks so much for being here for our next panel, which I'm really excited about. We are going to take a little bit of a detour through the world of high-impact litigation, specifically challenges to government action. As many of you know, class actions have had a renewed importance in that area over the last year or so. Last year, the Supreme Court issued a ruling holding that federal courts lack the authority to issue nationwide or universal injunctions. And as a result, that remedy has sort of been taken off the table in most cases involving just a single individual plaintiff. So there's a renewed interest in class actions, and we're going to talk through how the Trump v. Casa case changed the landscape and how a lot of the advocates have been responding to that. So as part of that, we're so lucky to have with us two of the foremost advocates in this area to talk us through some of the strategies and some of the considerations that are in play right now. So I'm just going to ask each of them to introduce themselves. Why don't we start with Erin Meyer?
Hi, everyone. I'm so glad to be here with you today. My name is Erin Meyer. I'm a partner here in San Francisco at Kecker Van Nest and Peters. We do mostly commercial and civil litigation, so you might be wondering why I'm here on this panel. I've spent a lot of my career on the other side of the V in class actions representing defendants. But one of the things that we have focused on at our firm and me personally in the last several years, especially post-Trump v. Casa, is thinking about the use of the class action mechanism in challenging government action that we assert is unconstitutional or unlawful. So I have a case in particular in the district that we are litigating that we got provisional class certification in, challenging certain policies of ICE related to redetention of non-citizens who had been previously released by the government. And so we're litigating that. My firm is also litigating several class actions in other districts in California, challenging other government policies. So I'm really excited to be here and to talk to all of you about this important topic today.
And then if Spencer, you can introduce yourself as well, that'd be great.
Hi, everyone. My name is Spencer Amda. I'm a senior staff attorney at the ACLU National Immigrants' Rights Project. And based in the Bay Area. And likewise, I'm super excited to talk about class actions in this area. You know, I started doing this kind of work about 9 years ago. And at the time, we basically never tried to certify a class. I think maybe I had one class case in my first 5 years. And now by 2026, almost every single case is a class action, whether it's against a state or the local or the federal government. So this has definitely become, I think, for anybody litigating kind of rules, civil rights, public interest cases, the class action and many issues within it have become kind of a front and center part of the work. I'm going to start us off by, we're going to talk about kind of how we got here to where the class action has become such a prominent part of litigation. And we'll start by talking about the lead up to this case, Trump versus Casa, that Judge Lynn mentioned. First, I'll just say the issue that Casa decided, whether there can be nationwide injunctions, has been bubbling up for a very long time, like really since the end of the Obama administration. There started to be lots and lots of extremely broad injunctions against executive policies. And the pace, continued through the first Trump administration, through the Biden administration. There were sort of arguments for and against, people who supported nationwide injunctions sort of pointed out that you can't have millions of people all bringing their own case when there's a unified policy, you want one answer. On the other hand, critics accused litigators of forum shopping and, would say that nationwide injunctions mean the government had to win every case in order to keep its policy on the books. So this came to a head in CASA in litigation over the administration's birthright citizenship policy. There was an executive order on day one of the current administration purporting to take birthright citizenship away from a very large set of people. People, including our office, sued immediately in many cases all at once, and judges all across the country issued nationwide injunctions. So sort of overlapping with each other. And any one of those injunctions would have been enough to block the policy. The government appealed, but did a sort of interesting thing that finally forced the issue to the Supreme Court's docket for a decision, which is that they sought a stay of the injunctions from the Supreme Court, not on the merits, but only on this issue of whether the injunctions could be nationwide or if they had to be limited to the plaintiffs.
So I'll talk a little bit about what the court actually did in Trump v. CASA and how the ruling came about. The Supreme Court, as you likely know, did not decide anything related to the merits of the birthright citizenship executive order. They explicitly did not take that up in Trump v. CASA. Justice Sotomayor, in her dissent, did spend quite a bit of time talking about the constitutionality or lack thereof of that order, but the majority didn't touch on those issues. The majority limited its decision to the remedy, whether lower courts had the authority to issue universal injunctions. And the court did use the term universal injunctions as opposed to nationwide injunctions. So I'm just going to use that terminology here as I talk about the opinion. It was a 6-3 decision written by Justice Barrett. Justice Sotomayor dissented, joined by Justice Jackson and Justice Kagan, but Justice Jackson wrote a separate dissent. In the majority decision, the court found that universal injunctions likely exceed the equitable authority granted to district courts in the Judiciary Act of 1789. And so they go way back with a history lesson. As with much of history, many things can be debated, but I'm going to tell you a little bit about how the majority looked at this issue. So under the Judiciary Act of 1789, the court's equitable powers are limited to those powers that existed in the courts of chancery in England prior to our nation's founding. And so the majority looked at a number of different mechanisms or different ways that cases were brought before the courts in England, and found that there was nothing comparable to universal injunctions. But for our purposes here today, as we're talking about class actions, I want to note one specific thing that the majority pointed to, which was something called a bill of peace that was used in courts in England. And a bill of peace was a form of group litigation that brought cases on behalf of people who were similarly situated. This may sound familiar, and what Justice Barrett said is that the Bill of Peace was not something that could be compared to a universal injunction. Instead, a Bill of Peace is what ultimately became the Rule 23 class action as we know it today. And so Justice Barrett in the majority in Trump v. CASA drew a direct through line, as we're thinking about equitable powers, from the Bill of Peace in England to Rule 23 class actions as they are used in federal court litigation today. And so I think that's really important as we talk about how we're using class action litigation in the context of rule of law issues going forward. And so just taking a step back, Justice Barrett and the majority said, because there's no analog from prior to the country's founding, there is no equitable power under the Judiciary Act for district courts to be issuing universal injunctions. And that's how we got to the ruling that we did in Trump v. CASA. There was also some discussion, which I think is interesting, in the decision about the concept of complete relief. And that was something that the advocates who were arguing in favor of universal injunctions pointed to. It's difficult to get complete relief if you cannot issue a universal injunction that just says, hey, can you hear me? Okay, I'm back. That just says, hey, this executive order is unconstitutional and that's going to apply nationwide. And so the court said, there may be some instances where it is impossible to get complete relief in the absence of a universal injunction. And they gave the example of a public nuisance. You have a neighbor who is playing loud music at all hours of the night, and there is, the order can't just be the neighbor can't play loud music and annoy you. It has to be the neighbor can't play loud music. And then there's a beneficiary. The neighbor on the other side gets the benefit of that relief as well. But the difference, as the court pointed out, is that the neighbor, if the person playing loud music violates the order, that neighbor who didn't sue in the first place can't challenge it, right? They can't enforce it. They have to file their own suit. And so the court did talk about that. We're going to be talking about complete relief and how that comes up in class actions as we go forward today. So I just wanted to flag that. And then the court, obviously foresaw this issue, that Rule 23 class actions were going to increase in the wake of this decision. And so they cautioned judges at the end of the majority decision not to ease the Rule 23 requirements for class actions in response to the decision removing the ability to issue universal injunctions. That was the majority's cautionary language to the district courts. But I think we're going to talk about why advocates, at least, who are bringing class actions, don't see any requirement to ease the Rule 23 requirements in the B2 context. We'll talk about what that looks like, but that is something that the Supreme Court has already flagged, and I suspect we'll see some more litigation about in the coming years. The one thing I haven't flagged is Justice Kavanaugh's concurrence in the majority opinion. Justice Kavanaugh he said a lot of interesting things in his concurrence, but he specifically mentioned that class actions and other procedural devices, like proceedings under the Administrative Procedures Act, which can stay executive action and policies, could still allow courts to fashion preliminary relief in the absence of a universal injunction when appropriate and consistent with Rule 23. So that's something specifically called out by Justice Kavanaugh. We'll talk about what that looks like in the wake of Trump v. Casa.
And I will say that from the district court's perspective, we have seen a huge uptick in terms of cases that are challenging actions of the government at any level, in cases that are seeking provisional class certification, which we'll walk through a little more, but is really an attempt to get this class-wide relief at the preliminary injunction stage. So, which brings me to ask Spencer about the next chapter of the story. What happened after the Supreme Court entered this ruling? Was there a reaction from the advocates, and how have they been using this procedural mechanism?
Yeah, so I think the way the story goes right after CASA is a little bit of a preview of kind of the state of the world more broadly, now that nationwide injunctions aren't a thing anymore. And part of the preview is that it's not clear that it's as big of an earthquake as you might think. So right after the CASA ruling, which took away these nationwide injunctions, and so was poised to put the birthright citizenship policy back in place, we and others as well in parallel moved for class certification right away. Everyone had the papers written, ready to go, because it was clear that this was going to be the mechanism that remained. And a judge in a different case, we filed it as a separate case, but before the same judge. So it was effectively the same thing, but in a case called Barbara versus Trump. The judge certified a nationwide class and enjoined policy nationwide once again, as to every member of that class. It was a fairly straightforward thing because, we were not dealing with a sort of complex corporate policy that might affect different people differently, and different people might be entitled to different amounts of damages or something like that. This was one unified, simple written policy, and it was clear who it would apply to. And so, I think within a week or two, I forget how many days, essentially the same nationwide relief was back in place. Before we talk about 23B classes in a little more detail, I just want to mention another wrinkle to this, which is that it's not only nationwide injunctions that have been pared back, it's also statewide injunctions. So this was not high profile because it wasn't a merits ruling, but it's had a real effect, which is, I believe, is in 2024, the Supreme Court issued a statewide injunction in a case out of Idaho, challenging a ban on gender affirming care. And the court had issued a statewide injunction in a case involving, I think, 2 individual plaintiffs. And the Supreme Court stayed the injunction as to everybody but those 2 plaintiffs, sort of sending a signal that the same headwinds against nationwide injunctions that, I think many circuits had already been implementing even before CASA. It was a pretty strong signal that those same principles might apply to statewide injunctions. And so the necessity of certifying classes extends beyond lawsuits against the federal government. It's also lawsuits against really any level of government.
Spencer, can I ask, were you doing class actions prior to Trump v. CASA at all? What situations were you doing it, if you were doing it?
Yeah, actually, because of this kind of writing on the wall point, I would say, the Ninth Circuit in particular, I mean, there were some conflicting decisions, arguably, but had some decisions years before CASA saying, at least not always going to do nationwide injunctions. You're going to need a really good reason. And so, circuits had started paring back, and I think the widely held expectation was that the Supreme Court, when they finally did decide the issue, would severely limit them, if not wipe them out as they did. And so I couldn't say when exactly, but approximately 2023-ish, I would say we and many other advocates started, not in every case, but in many cases, moving to certify. So at the beginning of the case.
Yeah, that's really interesting because from the district court perspective, I know that we really started seeing a lot more of those after Trump v. CASA. And prior to that, I wondered whether they would be coming before the Supreme Court entered its opinion, but we didn't see it very much. So it's interesting to hear from the other side. And will you tell us a little bit about the Rule 23B2 standard and how that applies in the kind of provisional class certification context where you're seeking a preliminary injunction on a short timeline, haven't had a chance for discovery and all that?
Yeah, so let's just kind of zoom out. What is a 23B2 class? We all probably know, but a B2 class is a class that is only seeking injunctive relief or declaratory relief. No request for monetary damages. You don't get into those Rule 23B3 requirements of predominance and superiority, which in practice can really complicate the class certification decision. And so if you have handled class actions, whether from the plaintiff side or the defense side in civil cases, consumer class action and employment class action, you know that there's often a lot of really complicated discovery that needs to happen before you ever get to the class certification stage. It can take a year before you even get to that stage. In cases where you're challenging government action in the context of a proposed 23B2 class for injunctive relief, it does look a little bit different. And part of that is it has to do with the precedent in the Ninth Circuit about how judges are supposed to think about class certification under B2, especially in cases challenging a single government policy or a single executive order. So I want to talk through that. The same requirements need to be met for a B2 class that we all kind of think about when we're bringing a class action. You have to have numerosity, commonality, typicality, adequacy. You have to have all of the 23A requirements to get a class action certified. But what we know from the Ninth Circuit, and there's a case called Parsons that I think is helpful, is that in the context of a challenge to government action, B2's requirements are unquestionably satisfied when members of the putative class seek uniform declaratory relief from policies or practices that are generally applicable to the class as a whole. What that means in practice, and this is actually from the Supreme Court, and from Ninth Circuit cases, is that if the court can answer the question being posed, whether a government action is unlawful, in one stroke, and that isn't dependent on differences between the class, then often Rule 23b2's requirements can be satisfied. So we have some important precedent from the Ninth Circuit when we think about how to handle these cases here in the Northern District and throughout California that I think are really helpful. I think the one thing that can feel, if you're bringing a B2 class action, challenging government action, you might think about, okay, well, how does ascertainability play in here? Because if I have a class of people who are affected or may be affected in the future by a policy, it might be difficult to actually identify who those people are. The other thing that is interesting in a B2 class, and the Ninth Circuit tells us this in a case called Briseño and in cases following Briseño, is that the ascertainability requirement is present for B3 classes seeking monetary relief, and not in B2 classes. So you don't have to come with your class certification motion with a plan, or at least under my read of this precedent, is that you don't need to come with a plan of exactly how you're going to come up with a class list, because you might have future members of a class that you can't yet identify. And under 23b2, there is precedent saying that that is permissible. So these are all different than some of the considerations we think about when we're thinking about B3 class actions you might be talking about in the other panels today. And so I think all of these are really important issues as we grapple with what Trump v. Casa means for these kinds of cases.
And how do you see that playing out in the provisional class time frame, where you're trying to seek a preliminary injunction on really expedited timeline without any discovery?
Yeah, I can say how it's kind of playing out on the ground in some of these new cases as they're being filed. As I said, almost every one of our cases is now a class action from the start, and so instead of starting with a complaint and PI motion or TRO motion, we're starting with those and a class cert motion. One thing I will say is, at least in my experience so far, the class cert motions in this context are sometimes very simple. And I came to this having not really litigated class actions in a sort of discovery and fact-heavy context. And I was sort of surprised to see that there were all of these different doctrinal requirements that, in the context of a challenge to a uniform policy, often kind of collapse into each other. And so, if you have a common issue, if you have commonality because there's a common question of whether the policy is lawful or not, you're almost automatically going to have typicality, because the plaintiffs are challenging the same policy as everyone else. You're almost always going to have adequacy. If it's a government policy, the city in almost every case will be satisfied with the exceptions. And then, the 23b2 standard of kind of one remedy for all class members, I have yet to see a case, at least in this kind of context, where that analysis kind of diverges in any meaningful way from commonality and typicality. So that's one thing to say, is, it's a burden for litigants and for the judge, certainly. But at least in a lot of cases, the analysis in these motions is not that complex. There are questions, because you asked about provisional class certification, about sort of how deep do you need to go at the beginning. This is something that I think is in flux. I mean, we're going to talk about a number of issues that, you know, the post-CASA wave kind of puts more pressure on in class action law. One of them is this question of, can you provisionally certify a class before you've done a full analysis? You know, I would say so far that hasn't been a big hiccup in most places. You know, part of it is because in some sense, class certification is always provisional until final judgment. I mean, the court can always decertify the class. And so I would say most courts have not struggled too much to either call it provisional class certification and issue a class-wide injunction, or just call it class certification at the beginning and issue a class-wide injunction. One very interesting wrinkle, though, I think that the Supreme Court has sort of injected into these cases came in another case of ours called AARP versus Trump. We had sought, I mean, kind of an unbelievably emergency relief from the court, basically in the middle of the night on a Friday night, on behalf of a class of Venezuelan men who are about to be deported to El Salvador, to the prison in El Salvador. And the Supreme Court granted the injunction on a class-wide basis, even though there was no class certified, and even without analyzing the class issue. And that was the first time, certainly the Supreme Court had ever done anything like that. And it sort of has now raised a question in the legal courts of, you know, if there's a real class wide at the beginning of the case, do you need to do the class certification analysis at the outset? Or, you know, in a truly emergency posture, can you issue relief to a class without even deciding provisional class certification?
I'm curious if you all are seeing, I mean, I think at the district court level, when I look at a lot of the district court opinions that are analyzing provisional class certification, they are ticking through the Rule 23 A and B2 factors, but I haven't seen a lot of appellate courts diving deep into that, saying the analysis wasn't rigorous enough. Most of the action in the appellate courts when folks are seeking to stay the district court's entry of a preliminary injunction on a class-wide basis, most of the action seems to be about the likelihood of success on the merits, about irreparable harm. I'm curious if you all have seen a lot of appellate court scrutiny into the Rule 23 factors and the appropriateness of class-wide relief on appeals from district court opinions.
It's an interesting question, and I'll just jump in here. I'm interested to hear what you have to say too. I think, given what I was saying before, that the Ninth Circuit's jurisprudence on this really, for B2 classes, really collapses into a lot of common sense. District court judges are meant to apply some common sense to how a government policy is going to affect a class. I think that does somewhat simplify the process. And so we aren't, at least in my experience, I haven't been seeing that as much at the appellate court level. And I think what I would say, and what you'll see if you search for case law on this, is there's not different standards being applied necessarily for provisional class certification as opposed to quote unquote full class certification. The district court judges are doing the Rule 23 analysis in a rigorous way, even if the issues are somewhat simplified because discovery hasn't happened yet. And so I think that might be the reason that we're not seeing a lot of cases come out challenging provisional class certification, at least at this stage. I will say just, you know, not every case that's a class action under B2 is simple. The case where we filed a motion for class certification at the outset of the case involved an unwritten policy, an unwritten DHS policy. And so there was a lot of question about what the scope of the policy was and how it was impacting our proposed class. So we put in something like 26 declarations to trying to document, you know, exactly how we were going to meet all of the 23 Rule 23 factors. And so I do think courts are holding advocates to that rigorous Rule 23 standard, even in cases where it does kind of boil down to this common sense question.
Will you talk a little bit about re-injury and how that affects the formulation of the class that you're asking the district court to certify?
Yeah, I think for those of us who have been involved in these cases, many of the challenges we're seeing from the government in opposing class certification has to do with allegations that there's a lack of standing under Article 3, that perhaps the class reps' claims of injury are moot because the class representative had already received a preliminary injunction in their individual capacity or a habeas order in their habeas case in the immigration space. And so I do think that the government is really focused in on Article 3 standing and trying to argue that there is a lack of injury for some class members in proposed classes, especially in cases where the proposed class includes people who might be at risk of injury in the future. But I think from putting on my plaintiff's hat, right, in these cases, the way I think about it is that if you have a risk of future harm, it is something that if you kind of know how these policies are being enforced, you know what the government is doing, then it is a common sense inquiry about whether someone with specific characteristics defined as a proposed class member is at risk of future injury. And I think that's something you can prove up in these cases. I also think that in one of the things that we think about in these cases involving government policies is that sometimes there can be sort of fleeting Article 3 standing, right? Like in a case where someone might be at risk of being detained by the immigration authorities or being deported. You have to think about what the risk of harm is and how it applies in your case. And so I think there's a lot of arguments you can make about Article 3 injury, but bringing these types of cases, you have to expect that you're going to see these arguments in opposition from the government.
And sort of on a more human level, I've also been wondering, obviously a component of these cases is finding folks who are willing to stand up and bring suit as a named plaintiff and as a class representative. Will you talk about your own cases and what that experience has been like in terms of just getting folks comfortable with the class representative role and whether that's different from the conversation you have with people about just being a named plaintiff in one of these cases in general?
I mean, my experience has mostly been that the class aspect doesn't add that much beyond just the question of, are you willing to be a plaintiff? Do you want to bring a suit? Certainly in the current moment, there's widespread fear about participating in litigation in any way because people understandably fear all manner of retaliation that they could face. So that is clearly a big hurdle to being a plaintiff, filing a declaration, really anything, even anonymously. But so far, we've basically found that certainly like the class aspect of things adds a piece to the discussion that has to happen and the counseling that has to happen of the client. But there are not many obligations, I would say, that serving as a class representative adds for your typical plaintiff in a civil rights case, in a case challenging government policy. And so, yeah, I would say fortunately it hasn't kind of changed that aspect too much.
In general, is it hard to get folks comfortable with the concept of being a named plaintiff in these suits? I'm always curious about that. I wonder about it from the other side, but I don't get to know what that conversation is like.
Yes, I would say very challenging. I mean, it varies a lot depending on what people's citizenship is, what their legal status is. Those two questions alone really affect how vulnerable they are to sort of government retaliation. it's like if the government is the one deciding every day whether to arrest you or not, whether they detain you locally or they send you to Texas, whatever, whether they try to find some third country that will take you, but they don't bother. It's real power the government has over these people. And so even if it's doing something illegal and even if their rights are being violated, I would say at least in the immigration space, I think it's probably very different in other areas, but the vast majority of people out there in total, not even consider bringing a suit.
The only thing I'll add to that is I think, yeah, it's certainly a difficult conversation to have, and it's something that is really big and scary for people considering taking on these cases. But I think what I've been seeing in the last year is a lot of bravery in people who have been willing to stand up and say, this happened to me. I was detained unlawfully and sent to detention facility for 2 months. I don't want that to happen to others in my community. So I want to do what I can to help. And I think that is really commendable in this environment and understanding what people have gone through. And so I will say, yeah, it's a difficult conversation, but obviously we've seen a lot of litigation in the last year. And so there's a lot of people across a lot of issues who have been willing to take on these issues.
We have a couple more topics that I want to move through, but I just want to flag that we'll try and make sure that we reserve some time for questions at the end. So we're going to reserve around 10 minutes for questions. So if you have questions about how, those of you who don't normally practice impact litigation, about how these cases work, or what it's like bringing these cases, I hope you'll start thinking about what some of those are. But let's move on to some of the other mechanisms that you all have been looking to try to get broader relief in the post-CASA world. So let me start with Erin.
Yeah, so I previewed this earlier when I was telling you about Justice Kavanaugh's concurrence in the Trump v. CASA case. But there is a mechanism under the Administrative Procedures Act that doesn't necessarily require the issuance of a universal or a nationwide injunction to get relief that is broader than just the plaintiff. So under Rule 705 or Section 705 of the APA, there is a mechanism to bring a motion to stay or vacate a government policy. That can be brought before it goes into effect or after it's gone into effect. And then Section 706, that's on the preliminary side, right? Like bring a Section 705 motion at the beginning of a case to say, hey, this policy is arbitrary and capricious, or it is unconstitutional, and you should stay it for XYZ reasons. And then there's Section 706, which is at the end of a case. It is a request, a motion for judgment that a policy should be vacated or stayed indefinitely. And so what Justice Kavanaugh was saying is, okay, that these motions to stay agency action under the Administrative Procedures Act, that's different than a universal injunction. And so it's not necessarily foreclosed by the court's opinion in Trump v. CASA. There's going to be litigation over what this looks like going forward. We've already seen in the Ninth Circuit, and this isn't necessarily true in other circuits, but the Ninth Circuit has issued a decision saying that for Section 705 motions for preliminary relief, those orders extend only to the named plaintiffs in the case. And so in the Ninth Circuit, and you may be seeing this in the district court, advocates are generally bringing class actions even where they are only moving for a stay under Section 705 of the APA as opposed to a preliminary injunction. There has been no decision, at least so far as I'm aware, in the Ninth Circuit, saying that a Section 706 judgment vacating an agency action is limited in that way. So I think that is going to be something to look out for as we move forward. I think there are a number of pending class actions where advocates are arguing that even if a judge is limited in issuing preliminary relief to the named plaintiffs or to the class, that maybe that might be limited geographically to Northern California, that at the end of the case, they can issue a judgment that might have nationwide effect. The argument goes that it's one policy, and so it shouldn't apply differently in different areas of the country. That's a little bit in tension with the Supreme Court's discussion in Trump v. CASA. So I'm very interested to see where that goes, and just wanted to flag that as something that is out there and that we're going to see a lot of development on, I would say, in the next year.
Yeah, I'm curious whether that advocates, this is for both of you really, have a view on like the tea leaf reading about the Supreme Court's view of whether the APA nationwide vacatur of a nationwide policy, even if it's just being done on behalf of a single plaintiff or a more limited class in some ways. I know that that was an argument that was made under the Biden administration, but Solicitor General Prelogar had asked the Supreme Court, it floated the possibility with the Supreme Court about the possibility that, vacatur is not such a broad form of relief, and maybe it should be cut back. And it sounded like there was maybe some pushback from some of the justices on that. So I'm curious what your tea leaf reading is about all of that. And we won't hold you to it. I think we'd be interested in hearing what you think might happen around that.
Yeah, I mean, don't quote me because I have no idea. I will say, I was actually when you started asking the question, gonna raise that same moment at that argument, because on the one hand, it sort of seems like a sort of too easy sidestep around CASA to say, okay, you can't enjoin federal policies nationwide, but you can vacate them nationwide, and you can probably accelerate summary judgment because it's an APA case, so there's no discovery. On the other hand, Justice Kavanaugh, Chief Justice Roberts, they come from the DC Circuit. I don't remember the quote exactly, but I believe what they said to the Solicitor General in that argument was, judges in DDC, we vacate, 5 policies after breakfast and another 5 policies after lunch. And those, that vacater is always nationwide. You vacate the whole policy. So I think it's hard to predict because there's sort of there's this pretty deeply ingrained sense, at least within the DC circuit. I don't know as much of a sense for other circuits on this, that vacater, which comes from this language set aside in the APA, that it means that you vacate the entire policy, even if it's just a limited set of plaintiffs with no class. But I will say that it's an issue, we were talking about kind of the lead up to CASA and the debate over nationwide injunctions, and there was an immense amount of kind of historical scholarship about the Bill of Peace and all these antecedents. And you're now seeing that same kind of scholarly debate, I would say, emerge over the legislative history of the APA and whether Congress, in more recent times meant to create this more comprehensive remedy against agency action. And so, yeah, it'll be really interesting and I think really consequential because it does remain a major way to not, federal policies. And I assume the court will have to decide pretty soon.
I agree with everything Spencer said, and I think it makes a lot of sense, right? If you have agency action that applies in California and not in Florida, or the other way around, that's kind of what Justice Kavanaugh was getting at, this concern in his concurrence, that you can't have this patchwork of ways in which the policy can apply nationwide. But that is kind of exactly what Trump v. CASA says as we look at universal injunction. So I think there's a little bit of tension there. I'm super interested to see what happens, but I do think that the better way of reading the law is that 706 vacatur can apply nationwide.
Let's shift gears a little and talk a little bit about the possibility of using bringing suits through associations as plaintiffs, or like unions or organizations that work with certain groups, nonprofits. What are some of the ways that those types of lawsuits can do something that's similar to class action, but without going through the whole Rule 23 analysis?
Yeah, so this is kind of an interesting mechanism that just already exists and is pretty well established. And it can achieve something short of full, universal relief. It is kind of a form, it's almost like a pseudo relief. And the rule is simple. It's that when an organization sues on behalf of its members, so by identifying members who would themselves have standing, the remedy that the organization gets is one that applies to all of its members. And so what that means is if you have a large enough organization with enough members, and there are plenty of organizations that have millions of members nationwide, again, you don't get the policy enjoined as to everybody in the country, with kind of no further requirement other than that being your plaintiff. The remedy can apply to a large number of people at a time. I will say that is a rule. I mean, that's been the rule everywhere so far. Now that CASA has been decided, there's a little more pressure on it. So we are starting to see government defendants raise questions for the first time. So this might be yet another one where a kind of new analysis is going to be required.
I'm curious, Erin, you mentioned complete relief earlier. How do you see that mechanism, associational cases? How do you see that interacting with complete relief? In order to give complete relief to an organization that has lots of members, are you able to effectively get nationwide relief? Talk us through some of your considerations on that.
Yeah, I think one of the things that we talk about when we talk about complete relief in the context of a government policy is the idea of operational indivisibility, right? So if an agency is going to enforce a policy, is it actually feasible for an agency to enforce it as to people who are not class members or not members of an association, and then not enforce it as to those people? In most cases, that doesn't make a whole lot of sense. It does seem to be, in some cases, we're seeing what the government is arguing for, that, an injunction or a Section 705 order that a judge is issuing is too broad. It goes beyond complete relief just to the class and ends up creating benefits for people who aren't class members. So it's a really tricky issue because it does seem to me to be throwing common sense out the window. And I think the way to deal with this, and I think we're just going to see a lot more jurisprudence on this in the coming year, but as an advocate and sort of from a common sense perspective, the way to deal with it is when you're defining your class, when you're putting your case together, thinking really carefully about what your class definition is just so important. Because how do you, from a plaintiff's perspective, how do you get the most protection you can for the broadest class in a way that makes sense and doesn't run afoul of Rule 23 or Trump v. CASA or whatever the limitations might be? I think defining your class in a way that allows you to still have commonality, but to expand the impact of a preliminary injunction is the best way to avoid this sticky complete relief issue that is going to be sort of percolating out there as we move forward.
And have you seen this? I know in the news there's been a lot about we're all watching the news with what's happening in Minnesota, and there's been a lot of kind of more challenges that are not necessarily based on a clear written policy, but more about the use of force or how individuals are stopped and all of those types of issues. How are you seeing that play out with this complete relief issue?
So I would say those cases which are class actions, in some ways they raise like a pre-CASA set of class action issues. That I would say harkens back to things like the stop and frisk litigation in New York City and other places, a decade ago. The litigation against, Joe Arpaio in Maricopa County in Arizona from, a decade or two ago, where it sort of goes back to something we were discussing the question of, are courts kind of questioning any of these class certification decisions. In Minnesota, the lawsuits about, retaliation against protesters, racial profiling and indiscriminate stops and arrests, those are very fact-heavy cases, and the policies are unwritten, and there are real questions about sort of, is there one unified enough course of conduct that you can say there's a policy at all that's affecting sort of an identifiable set of people in a similar way. So, in the case I'm working on, which is about stops and arrests, that's actively under dispute, and we're going to have a decision in a couple of weeks. The Eighth Circuit just issued a stay of an injunction in the parallel case about retaliation and use of force against protesters, class certification grounds, where they said, the panel said that sort of the alleged abuses were factually too different as to different people, and so class certification was unlikely. But what I would say about those cases is I don't know that before CASA those cases would have been brought as anything else other than class actions. I think just in the realm of kind of police practices, the class actions have sort of always been the way of doing things.
Erin, what is your experience with that and the conditions of confinement type cases that you were mentioning earlier? Does that raise similar issues for you all?
Well, my firm is handling conditions of confinement cases specifically with respect to California City, the detention facility down in California City. But I was thinking in particular, it does present a huge challenge when the government doesn't write down what its policy is. Because you do have to do a lot more of the factual development up front to prove up, hey, this is actually a policy. This is happening on the ground. It's happening uniformly. We can prove this. But that takes a lot of legwork in advance of even filing the case, in advance of filing the class certification motion. But just to be very clear, the precedent out there is that the government can't avoid executive agencies can't avoid review of their policies by deciding not to write them down. You can challenge unwritten policies under the APA, under other statutes, for constitutional grounds. And so I do think the factual record is more complicated in those cases than when you're just challenging a written policy, but it's still possible. Just takes a little bit more work.
I promised I'd give folks an opportunity to ask questions, so this is your opportunity. I hope you have thought of some good ones for our panelists.
My mind, for example, particular asks for injunctions, namely especially affected by birthright suspicion order, and they ask for order to essentially render invalid by injunction. That could be limited one person, but the benefit will fall everyone else. So basically, it's like better than suspicion order.
Yeah. I can just talk a little bit about the majority decision, and then I'd love to hear your thoughts on that.
Did folks hear the question, or do you need it repeated? Will you raise your hand if you need it repeated? Okay. Will you repeat the question?
Sure. So the question is just understanding a little bit more in Trump v. Casa, how the court thought about sort of incidental benefit to others who are not plaintiffs in the context of, and you let me know if I get this wrong, but in the context of the birthright citizenship case, there could be an order saying this executive order can't be enforced as to you because it is unconstitutional or whatever it might be, but then there are incidental benefits to others. by that order, by the executive order being unenforceable. And I think in the birthright citizen, did I get that right, first of all? Yeah. In the birthright citizenship case in particular, I think the court was thinking about it like, okay, this is something that we think can be limited, because we can say, okay, you just have to give, you can't take citizenship away from the child of this plaintiff who is pregnant, right? And I think they were trying to limit it in that way. There were states who had filed lawsuits, there were associations who had filed lawsuits, and the court didn't specifically weigh in on the appropriate scope of relief as to the states. They said, we're not going to touch that. You go back down to the district courts, let them decide in the first instance what a more appropriate, narrower injunction would look like, because the states had argued, well, it's not just, this executive order might apply. You can't just limit it to within our state, because people are very mobile. People are moving all the time. How do we prevent, an impact of someone who is a resident in Massachusetts but is across the border in New Hampshire when they give birth? Those kinds of questions. And I don't think that ended up getting teased out in the aftermath of Trump v. CASA, because everybody did file nationwide class actions. But Spencer, if you have other thoughts, I'd be interested to hear them.
No, I mean, I think that's right. I think that the limit the Supreme Court was understanding itself to impose, I think, is a fairly drastic one, where, if two parents or two children sue and they say this whole policy is illegal, you can't treat any of us like we're non-citizens, you have to treat us like citizens, and they win, the district court, at least, I mean, it's really, I think, first and foremost, a rule that disempowers district courts, because the rule is the district court can say, treat these two children as citizens, and the other, 400,000 people in the country born this year, you can treat them as non-citizens. An appellate court decision might still have a broader effect within the circuit. The Supreme Court's decision will still have nationwide and can shut down the policy. But, I think just mechanically speaking, we're talking about like extremely narrow district court orders.
Any other questions? Yes, in the front row. And then in the row behind you after.
What have you thought about the difference between the technical 705 and 706, the APA? 706 is the set aside language, which I agree with you, Aaron. It's the apply universal vacatur, but 705 has that language that's necessary, proper to basically preserve the surrounding rights until the final 706 ruling is handed down. Is that sort of a distinction that you might have interim relief that looks more like Trump v. CASA, that's more limited, whereas once we get to the final judgment, 706, then you set it aside, or that help?
Yeah, did folks hear that? So the question is about the textual differences between section 705 and 706 of the APA. And I think you're absolutely right that language is what led the Ninth Circuit to limit relief on section 705 in particular to the plaintiffs. And I do think that there is a textual argument that relief under section 706 is and should be broader. That's not to say that I necessarily agree with the reasoning in the Ninth Circuit decision that required section 705 decisions to be so limited, but I do think that is the language that courts are using to distinguish between the preliminary relief and the ultimate relief in the case.
Early class certification, any injunction, the governor seeking relief on 20 together.
I can repeat the question for the audience. It's where the district courts have been provisionally certifying classes and granting preliminary injunctions. Has the government in those cases been seeking a right of immediate appeal under Rule 23F concerning the certification decision? I can say from my vantage point, looking at district court opinions that are in this area, as I'm working in this area, I have not seen a lot of 23F appeals, probably because the government could just appeal the preliminary injunction itself. And so they are appealing both the preliminary injunction and the provisional certification order, which is usually the same order at the same time. And they don't need to resort to the 23F mechanism. But I'm curious if the others have seen anything different.
I would have said the exact same. Yeah.
Same. I haven't seen any standalone 23F petitions in these types of cases.
Any other questions for our panelists? I have a question for the panelists about clear. Spencer, you mentioned that as someone who's been doing impact litigation for a while, you had some class action experience, but you hadn't done a lot of class action experience, or you hadn't done a lot of class actions in your own practice. As you're looking for partners who will help you as pro bono counsel, is that something that you're trying to target, finding folks who have class action backgrounds? And I think similarly, the question to Erin is, as someone who does come to this with a class action background, do you find that you have folks who are reaching out, who are trying to find pro bono counsel who have this deep class action experience, who can, do ascertainability in their sleep or whatever it is? I'm just curious how that is playing out for both of you.
Yes, you see the answer for me. I mean, we're always looking for partners. I'm doing firms doing pro bono and others. And it's a huge plus when people have class action experience, especially in some of these cases, like the Minnesota cases I was mentioning, where the class action aspect of it does have a lot of weight on it, and there are a lot of disputed issues because it's such a fact-heavy case. I would say working with law firms with a little bit of experience in this area has been essential. I also would say we are, to the extent people are interested in partnering with awesome people like us, so not so picky. If you don't have that kind of experience, we still want to work with you. Yeah, that's been my experience.
Yeah, it's been really fun for me because I think a lot of my experience on the other side of the V doing defense work in the class action space has been, it allows me to bring a different perspective to the plaintiff side work. And I do kind of think I'm able to issue spot in a way that is, at least in my view, bringing something to the table. But I think, I just want to point out what Spencer said at the end of that. I think the numbers don't lie. I do think there has been a significant dip in the last year in law firm willingness to take on these types of rule of law cases and do this pro bono work. I think it is incredibly important to our system and to the way in which to the obligation that lawyers have to protect the rule of law. And so I think anyone who's interested in doing this work and partnering with amazing organizations like the ACLU and many of our other incredible nonprofits in the Bay Area who are really stretched thin these days, I wouldn't let a lack of deep experience scare you off from getting involved. I think it's doable to get yourself up to speed. You're here, doing this class action symposium today. I think it's very doable to figure out what the law is and do really incredible work.
Thank you all for participating in this panel. It was lovely having you here. And thank you all to the audience for being so engaged and preparing some great questions.
Thank you so much, everyone.